When people think of weeds, they probably think of ones like dandelions. How could the presence of weeds lead to a $500,000 verdict? As this three-part series will show, Japanese knotweed is a very different kind of weed, and the possibility of significant liability is real. In part 1 of this series, I will mainly look at legal developments in the United Kingdom, where knotweed has been a societal, political, and legal concern for decades. In part 2, I'll talk about real estate transactions, mainly home sales in the United States, and how they might be affected by the presence of invasive knotweed. In part 3, I'll look at nuisance and tort actions, primarily instances where a knotweed infestation from one person's property encroaches on another person's property. At the outset, I need to say, don't rely on these presentations for legal advice. If you need legal advice, do what any sensible person would do: consult a lawyer. What is invasive knotweed? There are 3 species that cause the greatest concern. They are Japanese or Itadori knotweed, giant knotweed, and Bohemian or hybrid knotweed. This fact probably encapsulates the issue of legal liability and invasive knotweed better than any other. In 2020, Japanese knotweed was knocking over 23,000 pounds off the average UK property value. That's 10%, a massive effect. Think of that, a $50,000 discount on a house selling for $500,000, all due to the presence of a weed on or near the property. What is so special about invasive knotweed that it can have this effect? Henry Graybar, in a 2019 article in Slate, perhaps summarizes it best. At the heart of the Great British Knotweed Panic is the fear that knotweed will make your house fall down. For various reasons, invasive knotweed always seems to be spreading, looking for new territory that it can expand into. This means it will sprout in all sorts of unusual locations, such as basements, a house soffit, concrete steps, or an expansion joint in an interstate entrance ramp. Because of this fear of the destructive capabilities of Japanese knotweed, in 2012, the UK's Royal Institution of Chartered Surveyors adopted a 7-meter rule. That rule stated in essence that if a piece of property had knotweed growing on it or within 7 meters of it, no bank should offer a mortgage to finance the purchase of that property. It is likely this rule, adopted by RICS, more than anything else, is responsible for the dramatic effect that Japanese knotweed has had on property sales in the United Kingdom. In subsequent years, RICS realized that the 7-meter rule was too restrictive. In 2022, RICS released a standard entitled Japanese Knotweed in Residential Property. The new standard changes the 7-meter rule to a 3-meter rule. Moreover, even the most infested sites can get a mortgage if a Japanese knotweed management plan is undertaken by a remediation specialist and there's an insurance-backed guarantee for knotweed control. The RICS standard justified these changes because of the, quote, normalization of knotweed as an environmental issue rather than only being a social/property issue. What have been the effects of these changes in the UK on property transfers? It seems to be too early to tell. What might happen in the United States? Could invasive knotweed become the social/property issue that it has been in the United Kingdom? That is really hard to say. There are only 2 reported cases in the U.S., Trites v. Cricones from Massachusetts and Inman versus Scarsdale Shopping Center from New York. However, the magnitude of the awards in those 2 cases is stunning. Are these cases outliers, or are they the initial rollers signaling waves of litigation yet to come? In any event, if you have property that is threatened with an invasive knotweed infestation, it makes sense to have a basic understanding of potential legal liability. Therefore, in part 2 of this series, I'll focus on real estate transactions in the U.S., like the one at issue in the Trites case. In part 3, I'll address nuisance and tort actions. The action in Inman was based on nuisance.